So every privacy professional knows that Noyb, the campaign group headed by Max Schrems, is a force to be reckoned with. But this week they gained new recognition that could give them even more ability to pursue GDPR violations. In this edition of the Privacy Corner, we'll be looking at those new powers. But first, the FTC in the US has taken action against sensitive location data sharing once more in the US under two new proposed consent orders. Australia has passed two very interesting bills, one of which reforms its rather ancient Privacy Act, the other of which will ban social media for under 16s. Then, thirdly, we're going to look at these new abilities for Noyb to bring so-called class action cases and issue injunctions against controllers and processors across Europe. So first up, the FTC. This could be one or two of Lena Khan's final enforcement actions as chair of the commission. She's likely to be replaced once Donald Trump starts his second term. There are two cases here concerning effectively three companies. First of all, let's look at this one against Gravy Analytics and its subsidiary Ventel Inc. So this is quite familiar territory for those of us who've been following the FTC's recent enforcement actions. They've had 5 against so-called location data brokers or aggregators, and this one is quite interesting because of its emphasis on mobile advertising IDs or MAIDs. So they are, this company, collecting 17 billion signals from approximately a billion mobile devices every day, according to their own representations and marketing. And it's not just Wi-Fi signals and GPS, but also these MAIDs that the FTC alleges represent location data, sensitive location data in some cases, and very accurate degree of location targeting here within 5 decimal places of precision, which would allegedly enable someone to identify not only which house a person is or which building a person's in, but which room within that building they are in as well. So this again is about sensitive locations, so churches, health related events, and market segmentation, as we'll look at shortly. One problem here was that the subsidiary, Ventel, was relying on its parent company to obtain consent and not checking whether parent company Gravy Analytics had in fact obtained that consent before disclosing data to third parties. In some cases, of course, it turned out that no consent had been given consent. So audience segments here, these are groups of personality traits or characteristics into which data brokers sort of put consumers according to their inferred interests. And we've got always have some interesting examples from these FTC enforcement cases. Restaurant visitor during COVID quarantine, pharmacy visitor during COVID quarantine, CBD shoppers, new parents. This is the kind of stuff that the FTC hates. And it interprets its powers under consumer protection law rather broadly and says that companies need to be getting very active, opt-in, assured, informed consent for these sorts of data collection. The other case is against a company called Mobilewalla. Quite similar stuff. In this case, Mobilewalla was getting information from real-time bidding exchanges. So it would place a bid on behalf of a client, an advertising bid, and it would retain the data associated with that bid, whether or not it won the bid for an advertising slot. So the FTC does not approve of this. And again, it was helping companies target via mobile advertising IDs. So this is something that lots of companies deal with. Definitely something to be aware of. The kinds of inferences that MAIDs and other unique identifiers can give rise to when associated with location data, raw location data or from Wi-Fi signals and so on. And again, segments here that the FTC is not happy with. Pregnant women, Hispanic churchgoers, members of the LGBTQ plus community, pregnancy centers and maternity clinics. This is all bad news according to the FTC. So both companies seem to have escaped a civil penalty, but very, very harsh remedies nonetheless. They are ordered to delete all historic location data and any products developed using this data. So the FTC goes really hard on in cases like this. This could destroy a company's entire business model effectively. Not to say it will in this case, but that is a possibility. Next up, we've got Australia that has made some progress towards, firstly, its long-awaited Privacy Act reforms, and secondly, this interesting new bill that has passed banning social media platforms from having users under 16. So it's a slightly complicated but quite short law and carries some very heavy penalties by Australian standards. So 30,000 penalty units. Penalty units are currently valued, they go up and down depending on inflation and so on, at 330 Australian dollars each. So 30,000 penalty units is around 9.9 million Australian dollars, so around 6.4 million US dollars, to give you an idea of how much that is. And this law requires certain social media platforms to take reasonable steps to prevent age-restricted users from having an account. And age-restricted users in this context for now means under 16s. So there are some strict rules. Well, there are some rules around what types of data platforms can use to verify users' ages. So this is where we get into a muddle with these kinds of laws. They require some quite extensive data collection in order to enforce these policies that these platforms have to pass. And there's going to be rules, regulations passed, fleshing this out in more detail. But for now, they're not allowed to collect government-issued ID or use an accredited digital ID service unless they also provide an alternative means for people to verify their ages that would be reasonable in the circumstances. So I think we're going to get platforms offering a number of different options to verify your age, but they will have to be effective because the penalties here are quite high, not high by some countries' standards, but as we'll see, they are very high by Australian standards. Now, there are also rules on what companies may do with personal information they've collected pursuant to these policies, and they have to comply with a sort of purpose limitation principle. But there are exceptions for certain Australian privacy principles that come out of the Privacy Act 1988, and those have to do with sharing data with government entities mostly. And there are quite a lot of exceptions here. So we could also get government agencies demanding platforms hand over this verification data for other purposes, and they will be allowed to do so in most cases. These are the relevant Australian privacy principles. So you can see they're about complying with court orders, giving information to government entities, and so on. And next up, there is this Privacy Act 1988 Amendment Bill. This is one of two tranches of reforms that Australia is passing to its pretty ancient Privacy Act. Is slow progress, I must say. The commissioner there has been on about this for a long time. They need to make some progress on these reforms, and they have done so. They are quite limited, I must say. So there's new powers for the Office of the Australian Information Commissioner, the OAIC, but these penalties are much lower than we saw in that social media bill, which the maximum there was 30,000 penalty units. Here it's 200 penalty units, so about 66,000 Australian dollars or 42,712 US dollars. So much less scary sort of potential penalties for certain violations of the Privacy Act here. But that is significant because it was virtually unenforceable before. We have new transparency rules for automated decision making. So this is a little bit like Article 22 GDPR, but much narrower because it's only really a transparency obligation. Companies just have to tell Australians or people in Australia that they are doing automated decision making. There's no meaningful restrictions on actually making them. We also have some international data transfer rules that might be fun for Australian companies. They don't seem quite as extensive as the EU's, but nonetheless, there's a similar idea. There's going to be sort of adequacy list and an assessment to make for countries that are not on that list. Finally, Noyb, as mentioned at the opening, have been recognised as a qualified entity under the EU's Collective Redress Directive. And this means that they are likely to get pretty busy bringing injunctions and even so-called class action cases under the GDPR. So this has been quite a long time coming. Noy's been going through this process of being recognised as a qualified entity for some time, and it gives them basically it solidifies their ability to do two things. Firstly, bringing injunctions against companies they suspect of violating the GDPR. So they say they will use this against companies tracking users without consent, using dark patterns, selling personal data without a legal basis, using absurd wording in privacy policies, or transferring personal data to inadequate jurisdictions. Firstly, they will write a cease and desist. If the company does not comply with that, they will go to court and try and get an injunction. Secondly, and this is possibly the more significant of the two new abilities, they can bring collective redress cases. So it's rather crude to call it a class action. It's slightly different than in the US, but that's effectively what it is. They can bring cases on behalf of large groups of consumers to claim damages under the GDPR. Now, some countries, well, most EU countries do not recognize these kind of opt-out class actions we see in the US. So consumers actually have to opt into the case to be part of the class. But some, including the Netherlands and Portugal, do recognize those kind of opt-out cases. So you could be involved in a class action without even knowing it, and then suddenly you'll be eligible for some compensation or damages. So I think this will embolden Noyb, and we can expect to see lots of activity from them in the coming years. Thank you so much for your time and attention. Thank you, as always, to Privado AI for supporting this show, and I'll see you next time.